Good afternoon. My name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today we are going to discuss about an interesting article that was published by Labor Daily with Labor attorney Jung Bong-soo, and the article is entitled as Supreme Court decision to the Gwangju city government child care workers case. So could you explain about the background of the story, please?
Yeah. Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. So Gwangju city government hired 150 child care workers. So they operate this child care business based on subsidy from the main government. So those child care workers claim the overtime or weekly holiday allowance or annual paid leave, but Gwangju city government rejected to pay those allowances. The reason is they said they are not employee working for organization. This is a temporary organization. Also, the Gwangju city government is not their employer because their money is based on subsidy from the main government. So they said they are not employed. But however, those child care workers said they are employed because they provide the labor service in order to make money. Also, the workplace is decided in advance. Also, they had working hours from 9 to 6, but they had extended working hours. So, in this case, they are employee who earn the money under the control of the service provider or employer. Yeah, that is their claim. In this case, court ruled they are employee. So Gwangju city government had to pay all legal allowances later. Yeah.
I see. So I understand that this court appeal started in 2017, and it took about 7 years until the court ruling. So you're saying that based on the court decision that the allowances, various different allowances should be paid by the Gwangju city government to the care workers, child care workers?
Yeah.
I see. So could you explain more detail about this case, please?
So I think child care workers said they are employed. So it was harder for them to be recognized as employee because it had taken almost 7 years to get confirmed as employee. The reason was actually child care the provider or worker, they are taking care of children or child, like so it's hard to like usually how they earn is based on subsidy from government. So they claim against the Gwangju city government. So because Gwangju city government is not profit organization or company that earn money by hiring those the child care workers. So, but the child care's perspective, they are controlled by Gwangju city government. Also, they provide labor service like from 9 to 6. Also, they work in designated area. Also, if they didn't work hard, they could not be selected for further extension of employment contract. So, concerning those required items to verify whether they are employed or not, they were definitely employed. So the court ruled like that they are employed. So because of this court ruling, they could claim the delayed payment of overtime or nighttime allowance or holiday work allowance, something like that. Yeah.
So, according to the article, they already signed the standard contract the standard sample of contract. So it means that they gave an extra work, or they did not follow the standard contract, or they had given additional work to the child workers. Is that right?
Yeah, like they have they have a standard template for employment contract, but the main issue is Gwangju City government claim they are not employer because it's the special business based on subsidy from main government, so they didn't earn anything from this operation. So, however, court ruled Gwangju City government could control those the child care workers because they had to receive, also they can manipulate or operate their work in the site. So even though they didn't earn any money, but they could control those the child care workers. So the court ruled they are employees. So because of this decision, Gwangju City government had to pay a lot of delayed payment of wages like overtime or nighttime allowance or weekly holiday allowance.
I see. So this court ruling may give provide another alert to other city government apart from the Gwangju city government. So it can be a good example for other city government.
So more and more court ruled those workers as the labor standard control the workers. So it is very important we understand those kind of freelance or contract, whether they are employee or not. So in this case, we judged the case based on definition of worker. Worker is the provider labor service in order to earn wage. So this is a very important one. They earn the wage on regular basis, also on fixed term or in the fixed area or in the fixed time. So it's very important. Yeah.
I see. Thank you very much for your comment.
Okay. Thank you for watching. Bye bye.